I think without getting into the context of the point by point issues, on a broader perspective, I certainly understand that this is something that we could just let go and say, hey, let's just keep going as usual. So I'm not married to any of this, but the reason that all this came to light and was addressed for the council's purpose was because during that process, as Mr. Brumley stated earlier, there was, he didn't say the word chaos, but we were close to chaos in a lot of circumstances. This isn't just something to make changes for the sake of making changes. These were very serious issues at the time. I think unless you were actually experiencing that, you may not, you may not understand the seriousness of what we're trying to consider here. It is somewhat mundane. I recognize that, but I don't think it's something we need to leave behind. And I would like to move forward as quickly as anyone else, but I just don't want to drop it because it was a while back. And
Well, did we want to get some consensus from the council, though? I mean, I appreciate you. I mean, I totally appreciate your position on that. I mean,
Right.
I'm a little bit on the opposite of that, you know, but I don't know. I mean, I'm not sure we've heard from everybody. I mean, Joe, do you think we need to move forward with this, or is it worth all this?
Like I said earlier, it's up to them what they want done. I think they need to come to a consensus first before we do anything.
well, the reason it's here was because of the commission.
Right.
It's not because of me sitting here. It's because of the
It's
commission.
not your fault.
No,
Yeah, we're not, right,
But
right.
I think we need.
But they said the two things that
understand
remained
that.
at the last meeting, it came down to two things
Yeah.
at the end, but both of those things were non-legislative things, or things that can be taken care of, you know, the funding, the staffing, you know, we don't need to change the state law for that. So outside of that, the other things are,
Well,
Yeah.
another issue on the list here, and I don't mind, I'll drop this in a minute, guys, believe me. Another part of this was the vacancy term, that it should be for the remainder of the term as opposed to the next election cycle. That was a problem. I think everyone was in agreement that that needed to be changed, that it be for the entire term instead of having to put it through.
yeah, but Mary made a point about that. Your point was, but then that means you could have a non-elected representative for an entire term. Was that your point,
Okay.
Mary?
Basically.
I could give you an example. The city council with Angela Blake, they appointed her. The next election, and whenever, she ran. So I don't see why we need to make any changes because of that. Because if you want the position, and you know that you need to run for the position, then fine. If you don't want to run, then don't accept the appointment. So I don't see the need to change that.
I think what the kink in this has become now is when we've discussed how much trouble it's gonna be to change anything at the state level.
Right.
There won't be any problem at all at state level. It's what we iron out here.
Time-wise it will be.
Yeah, it'll
What do
be
you
a
mean?
problem at the state
Time-wise,
level.
huh?
Anytime you see anything at the state level, yeah, it's a problem.
It'll be an extended amount of time to
Yeah.
see, so.
But not only that, I'm always concerned about the unforeseen circumstances. You know, we think we got it figured out or something, but then the next time we do this, then we realize, like, you know, we switch to 90 days, for example, and then we realize, you know, we don't have to take that long, but then, as Mary mentioned earlier, the purpose of the 60 is you want some expeditious, you know, desire to this, you know, because you want to get done. You don't want a school board seat going unfilled for,
The 60 days
a long
almost
time.
made it because of the council's meetings and how we meet. We might not always meet within that 60 days. It came very close to the fact that any appointment that we might have made would have been illegal
Well,
because it was past the
but
60
we
days.
ran an extra. Yeah, well, I'm not
That's a
gonna get into
reality. I'm not
details.
making
Y'all-
this
y'all
up. That
can't
is
have
a
a special
reality.
meeting?
That's
Yeah.
what we were faced with.
Y'all can't have a special legislative meeting when it comes down to something that close.
Understood, but the reason for this 90 instead of the 60 was to try to, again, and what I'm trying to do, what we were trying to do is to eliminate all the hoops that we had to go through simply because of a difference of 60 or 90 days. This is to try to make it easier on everyone. It wasn't to try to make it more difficult. It's try to avoid things like special sessions and, you know, the other hoops that everyone had to go through to try to get this done on time and getting the commission
I
together.
apologize, I haven't read the law in quite a while, but is it 60 days for the commission and then an additional days for the council? Or is it 60 days total from the time we start to the time you appoint?
There's a 60 days to get it to the council.
Okay.
Is everybody in agreement on your side of what needs to be done? That's what we need first. We
Okay,
need,
from
we need a
the
consensus from you guys, that you guys, that
Well,
what
you
needs
know,
to be
you're
done.
talking the commission and then you're talking about other groups. So it's.
Okay, I am
which-
part of the commission. I just don't show up, Eddie boards show up and whatever. So, yes, the NAACP is stated in the law as being a part of it. So,
And Eddie Boyd sent us a letter too.
right, and he sent a letter. He is our representative on it. I'm president of Wicomico County NAACP, and we support it as it is. And I have no constituents that want anything changed.
Well, as a commission member and the chair, I think it does need, the council needs to decide whether the term that you're going to use. I think another change has to be done. It doesn't state in the bill of, like the last time there was a tie. What happens in the situation of a tie? Does it come back to the commission or does the council take the ball from there? I think that needs to be spelled out. You know, when you're moving forward, yes, you will always find something that you may not have addressed, and because every situation is going to be different. But if you're going to go back, if you're looking at, you're spending all this time to look at this, then I think it should be looked at completely and then go forward. The concerns that we brought were the concerns of the members that attended the meetings and did the process. I didn't mean to say that the NAACP wasn't involved, but the NAACP sent their representative. And of those people, these are the issues that we came up with that we had concerns with. The timeline, if everything goes exactly as planned, the timeline this last time wasn't as bad, even though we were, you know, in the middle of a term, starting of a term. But the issue is getting the word out, and then the timeline that you have to set up. You know, you have to allow a minimum of 2 weeks for advertising to let possible candidates know that they can apply, how to apply. Then you've got to have another couple of weeks of the process to start with the actual commission, to look at the applicants, and to accept or deny applicants according to what the commission members feel at that time. And then you've got to have your meeting, and you're talking about like 2 weeks probably in between every step that you have to take.
And you have to advertise for both public hearings.
And you have to advertise. As far as people, whether or not they can attend, you know, you try to advertise, you try to put the timeline out in the beginning when you start, so that when people know, if you want to do something, you make it happen, in my opinion. There are foreseen situations that can come up, a death in the family, something like that. But if you want to be on the Board of Education, then you need to make the process be your priority. Because what's going to happen when you are there, if you can't make the meetings, what happens to the Board of
You have a
Education?
situation where somebody
So-
was on vacation or
Yeah.
something and couldn't attend, and they won't,
Well, I think this body truly appreciates everything the three of you are doing, as well as the rest of the board. And we're definitely very grateful, and we value your opinion. And I think what you three are doing speaks volumes. I thought what brought us here was the fact that some commission members weren't showing up. And I think that's what got this started. And this committee is in its infancy, and who would have known that somebody would have passed right after the election, and you would have had to work on finding candidates before you even really work the bugs out. So I think that's the process that we're in right now, and we're listening to what you're saying. So thank you for what you do.
Yeah, thank you.
Well, I guess not to belabor this, but, you know, I'm going to tell you what these issues are again. If the council wants to say, there's no concern or no interest in addressing these, then we will wrap this up. But keep in mind, if there's any one issue that's important enough that we have to go to the state of Maryland, then all of them should be addressed. And I'll be glad to reschedule another work session if we want to get out of here in a timely manner today. The first item is the public hearings, minimum of one public hearing as opposed to requiring two. Appoint within 90 days rather than 60 days. To the consideration of reducing the large number from 14 to maybe 7. A lot of that, as was discussed previously, was eliminating the 8 municipal representatives because there was a problem with them attending anyway. The vacancy term, the remainder of the term, whether it would go till the next election or throughout the remainder of that term. If the first recommendations were refused, what would the process be after that? And what is the second option if there's not enough candidates to attend? So those are the issues of concern. If you guys want to drop it, you want to do it 6 months from now, you want to do it next year?
Well, I don't think we
I'm not
have to
married to any
drop
of it.
it, but it sounds like they still have some things to work out, and I'm willing to hear it if you want to work it out and to bring it back to us.
Well, that's a good idea, Larry. Maybe
Yeah.
if we give it to the commission members and let you guys sort through what you would like to do. I mean, that's what I think Bill said, that the commission is the one that should tell us what the problems are. If we give this list to the commission, maybe you have a commission meeting. You can have a meeting anytime you'd like.
That's right.
And sort it out among yourselves as how you'd like to resolve it. Would that suffice?
Yeah,
I think that would be the best thing.
and go down this list. This
Yeah.
is the list, go down that list.
You have one
Yeah.
meeting at a time.
I'd also
Yeah.
like to ask for, if you, when you have your meeting, to really think about what the administrative support looks like. Like, what is that gonna look like for you? I know you said a secretary taking notes, that shouldn't be on the chair to do it. So really hone that in on exactly what administrative support looks like.
That's a good idea, too.
And the funding as well.
Well, I can tell you this much, and because of
That needs to
the
be-
secretary part of it was not an issue. What I said before was that we were lucky enough, our secretary, in her job, she was able to make copies and send stuff out. And Joan also did the same thing as president of the Teachers Association, or educators, I'm sorry. But the problems with staffing were different than just a regular secretary. We've had a secretary since the very first meeting, when we elected a chair and we elected a secretary. And that part of it was not an issue. It's the publications of it
Right,
was
the
the
funding.
issue as far as
Yeah.
the staffing.
So just narrow
But we
down
can, I'll get Chris to send out an email and we'll schedule a meeting. But I think there is, one of the two things that really need to be addressed on the fairness of the candidate that is selected and appointed is the term. Whether, I mean, if it's only 6 months and they've gone through all this for 6 months, are you making it so that it is lucrative enough for somebody to step up? Or should they just wait 6 months and say, I'll run?
And that's something
that's-
you should work out.
Keep in
Well,
mind, too, the
that's-
first question we ask them is, are you going to run again?
That is.
Or are you just wasting everybody's time?
And I would like to interject that with regard to the term of the person who is put into the position, according to the statute, an individual who takes office to fill a vacancy for an elected or appointed member serves for the remainder of the term for which the appointment was made. So if, for Mr. Gosley, in having passed, now Tanya Lewis would serve the same term that he would have served.
Well, maybe.
I don't think that's correct.
Neither.
Yeah, that's not correct.
Our
Maybe it
charter says the same, whenever I went to file, I had issues.
Well, I think we're mixing up terms here. I think there's a different set of standards for the county council
Yeah, I'm
representative.
speaking now of the vacancy on the Board of Education,
All right.
not the council.
All right, well, she's reading straight from statute.
Well, there's
was there, like-
another sentence there, though, I think she's not reading.
It
Oh,
says,
sorry.
and until a successor or elected, appointed is elected or appointed and qualifies.
I know we went through this in June, and,
But doesn't it also say, or until the next election?
I thought there was
Yeah.
something in there about the
There is
next
something in
election.
there about the next election.
there is.
Because we went through this.
it'll take me a minute to find it, but it's.
All right, well, if you would be kind enough to try to put all the pieces together for us. We'll certainly send this to you as a guideline of what we felt were concerns. You're going to have more on your own, I'm sure, but if you don't mind getting the commission together to try to sort through it, we'd appreciate you taking that
Can I
time.
make one other suggestion on that?
Yes, Bob.
That they look at the memo I did September 8, which was summarizing the council's discussion on September 3rd. That was our very first meeting about this.
We'll supply them with that as well,
And-
Mrs. Hurley?
Because there are a couple other items on there. For example, there's the situation if nobody runs for a seat, how that would then be filled. In the memo that I did then, it was supposing that the commission was going to be eliminated. So the way I've phrased how that should be changed in the law is under that assumption. Now, if you're going to keep the commission, then perhaps it would become the body that appoints someone if no one files for election.
But we.
So that's
we keep-
that's a matter. If
but
you're
you-
going to go to Annapolis, I think it'd be wise to address that, as many other counties have.
But, Mr. Taylor, you keep going back to, that was our first meeting, but we had another work session after that and came to some general consensus.
Not on this, I don't think.
Yeah,
Not on
what
this
was our-
point. I mean,
What
the-
was our,
Yeah.
the second work session we had was after this.
We've had a couple of work sessions after that.
Well,
September.
we could send the
We keep coming
commission,
back to the first one.
we could send the commission a copy of both of the work
Yeah,
sessions.
that's what I'm saying.
We'll send them a copy of both of the work sessions so that the people that aren't here get a feel for what's been discussed,
Yeah.
okay?
Because
And that might
the
help you.
fact of the matter is, if nobody runs, you've got a problem. Somebody's got to fill the seat, or it's just going to remain vacant till the next election, 4 more years.
Right.
want that.
So,
And county council approved the appointment of each member. So it would seem that county council, rather than Chris Gosnell, Ben, or I, were asked to send the information to each member, and perhaps to each of the entities that recommended that specific member, so that everybody is informed.
Okay.
So should we send a message to all the members when you choose your next meeting date?
I think they should have staff that's doing that.
Or that
I don't
staff,
think-
I think that should be
it
established.
staff.
I'm not sure I
I think it should.
I don't think that's necessary. I think we've had, as far as Chris, our secretary, has done an excellent job of getting
Okay.
the word out to the members of the
That's fine.
commission. So I don't think that's a labor that needs to be put on the council unless you all deem that you want to do that.
I just want to make sure you have enough members.
And my concern too is, there's no meeting minutes.
There are meeting minutes.
Okay, because I asked for them and I didn't.
Well,
All right, let's, if you
I
will
can-
accept that charge, we appreciate that, and the communication is always open. So if you have any questions, feel free to call either me or a council member or Mrs. Hurley to try to get
can I address what she asked?
Excuse me?
Can I address what she asked before?
Certainly.
You have somebody meeting?
I apologize. I've worked as far as being on the Maryland PTA Board of Directors and National PTA. We work on the guidelines of Robert's Rules. And Robert's Rules states that one committee doesn't share minutes with another committee outside of that. The minutes are for that group only. If you want the minutes, I will see that Chris puts together a packet of minutes for you. But that's what we have worked under. And like I said, the quorum issue, of course, I know the Board of Education has to have quorum, whether they work under Roberts or I don't know about you guys, how you have to do it. But that's what I've always worked under for the past 20 years, so that's what I've carried into this as chair, to get some kind of order in our functioning. So, but no, we had minutes of every meeting, and the minutes were shared with every member. They were always sent out.
All right, well,
So-
we'll get everything to you guys. And then
Okay.
let you,
Thank you.
And
Figure it out.
I will let John know when we were going to meet, so
you can
have
either
that.
let me know or let
And,
Mrs. Hurley know. She has a better memory than I do.
Okay. And then, try to plan this to where it's not drug out for you all to have your meeting, because I know if you're going to send something to the state, you're limited on how much time you have before you do so.
Sounds good. Thank you very
Okay.
much.
Thank you.
Thank you.
Thanks.
Next item on the agenda was the Wicomico County 457B plan. We asked the executive to be here. The executive is not here. I don't know, we're trying to get things resolved countywide. The concern on the 457B plan, the retirement plan for the county employees, was that the plan was actually changed from Mass Mutual to Empower. There was a concern by the fact that we were getting very many calls from the employees that they had no idea what had happened to their retirement plan. Some of them had gone online and opened up the plan, and it said they had a zero balance. So they were extremely taken aback by that. There is a requirement that they be notified in advance before plans are changed, as I understand it. Not only that, but from what we've been able to decipher, that it appears that any major changes to plans, and I would consider this a major change to the plan, that the benefits possibly could not have changed, but that's also questionable. But all that aside, it doesn't hurt to sit down with the executive and to review this to see exactly what happened. It was a major
Change.
point of contention with the employees. And even though we don't oversee the employees, we do oversee the county, and we're responsible for the department heads at some point in time. So it'd be nice to know exactly what happened, and in an open exchange.
Yeah.
Mr. Taylor, were you going to add something?
Well, I was going to say that you had mentioned that this was a major change. Under the charter, I don't think it has to be major. It would be any change in a benefit plan.
Right.
Because that's the way the charter reads. And in terms of the 457 plan, that's been the practice in the past. As pointed out in 2014, there were some very minor changes made in the plan that then was with Mass Mutual. According to according to the minutes, it was noted that these were very minor by Mr. Strasburg, that these were a few technical changes that were made, but there was no change in the way the plan operates. So there was no change in the benefits or anything. It was just to make IRS happy under some regs they had issued that say what your plan has to say. And in addition to that, in the county's retirement plan, there have been a number of changes made in that that have come to council and been approved also. So the practice is well established. It's not something I've come up with out of left field. I don't know where you go from here. It seems to me that logic would say that you would review what they've done and approve it if you feel that it was a beneficial, worthwhile change. They could have come to council and presented it, and you could have approved it if it was so good. So that would be the first thing, and I think in the letter that was written to Mr. Culver on November 7, we asked that they provide information about who responded to the RFP, what their proposals were, how they were evaluated, why they chose this particular group that they have gone to. As I understand it, we haven't gotten any response, have we, Ms. Hurley?
We have not.
Have you even been told whether you're going to get one or not? So I guess it's, go pound sand type response. There were some other aspects of the process that you could see from what was available online. The RFP process had some odd things to it. They're mentioned in item 3 of the letter. I won't go over those. I don't think that's the most significant point of this, but they would be addressed if they would provide the material, and should be, in my opinion. And 4, as noted in there, and I think Mr. Cannon's already mentioned, there was, I guess, a shock and awe factor when people got a statement from the old provider saying that you don't have any more funds left in your account, because they had transferred them to the new provider, which meant that they zeroed out the accounts with the old provider. But beyond that, apparently there have been some concerns or complaints about the way certain employees have been treated when they contacted the executive branch about this. Whether you want to go into that or not is up to the council. And then there were some statements, and this involves a change that occurred with regard to Mass Mutual's, I don't know whether you'd call it a fund, but it was an investment option that had a guaranteed 4% return, which, as I understand, a good many employees were in. They like that factor that you don't have to worry about the bond market, stock market, this, that, and the other. And that has been eliminated, as I understand it. There were comments made to the effect that, comments by Ms. Ennis, that Mass Mutual was going to discontinue that. I have no idea whether that's the case or not. Perhaps Mr. Roser or Mr. Hitchens could check with Mass Mutual on that. Since this letter was written, it's come to my attention that in addition to changing the 457 plan, there was a second plan that has been implemented with Empower. What is it, a 401A plan? And there is a benefit to employees for this, because what happens right now under the 457 plan, we have a 20% match. In other words, the county puts in 20% of what the employee puts in. There's a cap under 457. Right now, it's about 19,000 and change. So essentially, the employee can put in 80% of that, because the county's match of 20% would be the other part. However, that's deemed to be taxable. But if you set up a 401A plan, then the employee can put that same amount of that county's 20% match, whatever that comes out to, into the 401A plan, and that's tax deferred. So it's a good idea to have it. My understanding is most providers offer that as well as a 457 plan because of that reason, that they often go hand in hand. However, I would note, just for your attention, that the 401A plan can also be used to defer further income depending on the relationship you strike with your provider, and also the county could match that. And I don't know what the executive branch has done in that regard. I think that's something I've just have come into, found out about, and I think is another matter that you want to discuss with the executive branch to find out exactly what the parameters of that 401A plan are going to be. Unfortunately, we don't have anything. How you go about getting it, perhaps a public information request. I don't know. I mean, I guess you could ask again. I asked once. I guess you could ask a second time and say, please avoid the rigmarole of a Public Information Act request.
Right. Well, two things come into play. One is it's required by law that the council be informed and be a part and approve these changes. I mean, that's required by law.
Correct.
People call it
Yeah.
a charter, but it's law.
Right.
The second part of that is that everybody here runs on the principles of open and transparent government. And that's why this is something that should be addressed publicly.
Yeah, I might also mention there's a provision in the charter that says the county executive has the duty to provide to council any information it requests for matters that are within its parameters and jurisdiction. And this certainly is, because, as I say, the charter expressly says that the council essentially establishes, modifies, and changes the personnel system, including the benefit plans.
Right.
So I don't know how you want to proceed on it, but that would be two options. One, ask again. Two, do a PIA request.
Thank you, Mr. Taylor.
Well, one point I'd like to make is that most of the county employees and retirees are residents of Wicomico County. So when there's an incident or something that concerns them, the first person they call is their elected representative. And there are many times such as this that we don't have an answer for them. And that gets old. That makes us look bad when we don't know what's going on in our own county.
Any other comments?
Well, I've heard concerns also from retirees and employees. I've heard concerns also from retirees and employees, and, it just seems one thing after the other when when it comes to the charter. So,
And just to make clear, I'm not suggesting there's anything wrong with Empower or changing to it. I just don't simply know. I mean, there's no way I could say anyway.
Right.
But I think it's a valid matter, and the council is essentially charged with running the personnel system.
Well, let's getting to your point, let's ask again.
Right.
I mean, we're obligated to do that.
Right.
The deadline.
The next item on the agenda, again, dovetails right back to the same set of circumstances. We have scheduled a meeting for legal services for Wicomico County to meet with the executive. We have a ghost executive, chooses not to appear at any meetings, which just really is not a productive way to try to run the county. As it is right now, Mr. Paul Wilbur is, I'm assuming, in meetings and signing documents as the county attorney, but Mr. Wilbur is no longer the county attorney. He has not been approved by this council. The 90-day extension has expired, and again, that is by law. He no longer legally represents, or is no longer legally authorized to represent Wicomico County whatsoever. What are the concerns? What happens when we need to go to the banks for bank loans? What happens when we're trying to ratify contracts? What happens when resolutions come to this table that are supposedly they are required to go through the county attorney before they come here? And all contracts are required to go through the county attorney before they're even signed. But we don't have a county attorney. So the purpose of this meeting today really was to try to find some resolution to this, and rather than, continuing down this road of conflict, the idea was to find some type of appropriate resolution to this, but the refusal to cooperate continues. I think it is the dysfunction that more than anything is what our constituents find to be so deplorable. And I can't help but agree with them. I've stated in more cases than not that, you look at how the city of Salisbury is being run. You look at the cooperation between the mayor and the council, and the cooperation between the mayor and everyone in the community. And you can see how Salisbury is continuing to grow. I'd like to have that same set of circumstances for Wicomico County, where we resolve those differences at the benefit of the county, and get this ridiculous conflict out of the way. There's no need for it. It's so counterproductive. But again, we have a work schedule session for the county attorney, because legally this county does not have a county attorney. That is a very scary situation for us to be put into as a county. Mr. Taylor?
Well, as you know, as council knows, instead of coming today to discuss things, what we got from the county executive on Friday was a letter from an outside law firm that he's apparently retained, or the county has, I don't know which. It's a little hard to tell from the letter, arguing that Mr. Wilbur really could continue as the county attorney. I've done a memorandum regarding that. I don't think that's the case. I would suggest sending that memorandum to the executive and Mr. Wilbur to at least avoid any notion that we have somehow acquiesced in what he sent on Friday. Beyond that, there are other things you can do. We talked about it, I think, once before, contacting the courts, putting them on notice that he's not really the county attorney. Again, it's up to the council how you want to proceed.
Right, and they seem like very extreme measures, but it's not any knee-jerk reaction. The public needs to recognize the fact that this is a process that's been going on for over a year. Mr. Wilbur was first informed of this a year ago. The executive branch was informed of this over a year ago. And they knew quite well that what was pending and chose to ignore it. More recently, prior to the 90-day extension, there was a lot of concern and I wouldn't say yelling, but there was a lot of exaggerated appeals that, we have to extend this. We can't possibly work without this. So, the council, left it as it might be. This 90-day provision went into effect, and even after 90 days, still nothing more was done. And now, as opposed to trying to address it again legally, it's just been said, well, we're going to keep on going. We're going to continue with this process. Mr. Culver seems to suggest that the charter is not really law. He stated that publicly, that it's just a guideline to go by. But this isn't like the bylaws for the Boy Scouts. It is state law, and it has to be, you're held accountable to it.
Yeah, I think it's worth noting, you mentioned a year, but it's actually been, since Mr. Wilbur was removed by council back in May, it's been almost 6 months.
Right.
When he knew that
When it was
Mr.
official.
Wilbur had been
When it
removed.
was official.
I mean, yeah,
But the
when it
first-
naturally been official, yeah.
Yeah, but the first attempt to make them aware of these circumstances was
Yeah.
November of 2018.
Correct.
And isn't hiring an outside attorney something that has to be approved by this body?
Yeah, the attorney has to be nominated by the exec and confirmed by the council. That would be a permanent appointment.
I'm talking about the attorney that was hired.
Oh, okay, I'm sorry.
Pertaining to that letter.
Yeah, I missed that one over my head. Yeah, under our charter, to have a special outside legal counsel, it has to be approved by the council.
Is there a way we could get guidance from Mako? I know this is a larger trend in government across the country. We see this in the President of the United States right now. Individuals in executive roles who do not want to pay attention to rule of law. Is there a model that is currently in place or something that, that Mako might recommend as a way to put teeth into the legislative body if there is a misstep, or if there's a way that the executives tend to roll over current law, there should be a recourse that should be put into law. Do we have the ability to create that recourse or to create the teeth in the law?
Well, I think that, first of all, I think that Mako probably would treat it like a hot potato.
Sure.
But yes, there is a way. I mean, the charter could be amended. I mean, you could actually have an impeachment provision. Wouldn't be unconstitutional. I don't know of any county that has that. Actually, I've looked at a few charters just out of curiosity. But that would be one thing. I guess another way to do it would be put in some sort of a penalty provision, either monetary or other. But all of these things, the problem is then you get into further disputes about that. If you see what I mean, it wouldn't be self-executing. So I think that, unfortunately, it's just one of those things. The alternatives to me are to put the courts on notice, also to put other people on notice generally, either by doing a press release, that would be to the media, so that people know. Not that many people watch PAC 14 and are listening to this today, I don't think. But there are other ways of spreading the word, and those would be some ways to do it.
Yeah, Josh, I don't think that Mako really has any guidelines to go by. I think this is really such an extreme case. I don't think they have any cases to sort of justify it. It's a little more irrational than I think any of the other counties in the state of Maryland have experienced. It's also one where you have to be very careful about going down a real slippery slope where it could become political. In this case, we have a majority of Republicans here. We have a Republican executive. There's not a political issue here. But in some counties, you're Democrat. If it's a Democratic or a Republican council and the opposing party is the executive, they could take advantage of any extreme measures for censorship or removal from office. So that's what creates that, what I would say is a very slippery slope. So again, it's such an unusual set of circumstances that we're faced with here that statewide, I don't think they are really prepared to know how to give us that advice. As Mr. Taylor said, it's going to have to probably come from us in some type of a charter amendment.
We can't continue to go down this road, and Councilman Hastings has a good idea, and I mentioned at the last meeting, we need to sharpen our pencils and start looking at some amendment changes to the charter.
Mr. Cannon, I have a
Yes.
question on the letter from the attorney, Mr. Kapinski.
Yes.
Kapinski. It says here that he represents the insurance carrier, the liability insurance. Is that-
No, he doesn't say he represents them. He doesn't say that in the letter, but at the bottom of the letter, he does note that the insurance company has asked him to sort of be a mediator, which I thought was very unusual because they don't take that role as Legit doesn't
Yeah,
take that role.
I was gonna say, I'm not really familiar with Legit and the
Right.
process, but
Mhm.
if the executive side is using this Legit,
Mhm.
do we have the same option of getting an attorney from Legit?
Well, and that's a good question, but as I understand it, Mrs. Hurley would say, Legit usually only gets involved if there's a group that's suing, that's filing a claim against the county. In this case, no one's filing a claim against anyone, so we're sort of at a bit of confused as to why Legit was brought into this. Mr. Karpinski doesn't say he's representing Legit, even though he does do representation for Legit. In this case, he seems to be acting independently, but in the last paragraph or two, he says, by the way, Legit is suggesting that I could maybe arbitrate for you, which sort of came out of left field.
I think we
Yeah,
need,
I just question that, and if we have the same luxury of using an attorney from Legit, and
I think we
Unfortunately,
need to find out really who hired Krupinski. I think we need to know whether the county executive's office hired him, or if they called the insurance company and the insurance company has stepped in and paying Krupinski's fee.
That's what I
Because
asked
I think,
yesterday.
I think we need to know, I think we need an answer to that. That could be a letter that could be sent sooner than later, I think.
yeah.
Yeah, I would suggest sending first to the county exec,
Well,
and if he doesn't
we could
respond,
send
then contact him.
We could send to both, we could
Yeah.
send them to both of them, but
Yeah,
I
that's
think
true.
it would be wise to find out who is paying the bill there. The other thing, regardless of who our attorney is or was or whatever, if this attorney isn't appointed or confirmed, and they end up in a court proceeding against whoever the plaintiff is, and the plaintiff's found guilty, or defendant, whichever, I guess you would call it, is found guilty, and then they find out that this attorney is not really a confirmed attorney of the county, wouldn't that jeopardize a case?
Taylor?
Yeah, I honestly don't know. I've never
Yeah.
been involved in that situation. I've been involved in a couple situations where the other party's attorney was discharged by that party, usually right before trial, to keep trial from happening, because then they can come in and say, well, I don't have an attorney. And there's a special rule for that that allows within a very short period of time, the client must get another attorney if he fires his or her attorney. But I've not been in the situation where it's actually gone to trial and there's been a decision, and then somehow it's been raised. I think it would be normally only if the prevailing party was represented by an attorney who wasn't authorized. Normally, if it was if it's a loser, nobody would care.
I think again, it puts us in some real shallow water there about where we're operating.
Just so it's said, this is the larger trend in government, and this is not something I don't think that's going to go away anytime soon. I think we do need to, unfortunately, we do need to start looking at parameters to be able to have recourse in these kinds of actions. And it's not just our body, it's counties across the country, and you've seen it across the world. So,
Yeah, I don't disagree, and Mako might at least be the source of some information in that regard. There's also the group that we joined, IMLA, and I can query them and see if there's anything from wouldn't necessarily have to be in Maryland, it could be anywhere.
if it's helpful for us to take another look at, last thing I'll say on this,
Yeah.
if it's helpful for us to take a better look at our
Right.
charter and how we operate between the county, the legislative and the
Yeah.
executive branch, then, maybe there's a lot of recommendations that could be put together. Maybe that's something that we could sit down with a mediator and come up with a broad spectrum of options. But as a whole, we all just want to play with the rules as they are put in place. And it doesn't, there are things that we don't have to handle or things that we could handle more. But above all else, we just want to play by the rules that are set in place. So it may be that we need to add additional rules in order to have a fair game.
Just to interrupt you, Josh, they're not rules, they're laws.
Oh, yeah,
Yeah.
rules are, laws are rules for
And
the,
that's
for
why
the
we have the
record.
that's why we have the charter review committee,
Yeah.
It certainly
Well-
seems like we've brought that up before.
Right.
The charter
Yeah, we do
is the charter is very specific what the rules or laws are. The problem with the charter is there's no ramifications for
Yeah.
when you break them.
Exactly.
That's the problem with the charter. I mean, read the charter. It
And
tells
that's
you
kind
what you're
of,
supposed
I
to
think
do and
it's a
not
good
supposed
question
to
that needs
do.
to be posed to the review committee for them to
But,
consider.
it's when you
Yes.
don't follow the rules or laws
Yeah, I think Mrs. Hurley has that on the list, Bill, as an issue, as one of the points to address with the committee when they're formed. All right, again, thank you, Mr. Taylor. We appreciate your review of this and the research that you did. Entertain a motion to adjourn so we can go into closed session after lunch.
So moved.
Second. All those in favor?
Aye.
Opposed? Means adjourned.